The Fair Housing Act was adopted and then amended in 1988 to include the associations and sellers cannot discriminate against renters or residents based on race, color, religion, sex, familial status, disability, and national origin. Hi, I'm Lynn Krupnick with Krupnick & Spies. I represent community associations throughout Arizona, and I have been representing community associations for the past 21 years. There is an exemption in the law, which was adopted in the Fair Housing Amendment Act of 1988, that does allow for associations to discriminate against children so that they can discriminate and not allow children in the community as residents. So generally the law states that associations cannot discriminate based on familial status, which is having children live in the home that are under the age of 18. But under the exemption, if an association qualifies, then they are not required to allow children to live in the community. For an association to be able to prevent children from living in the community, there are specific criteria that must be met in the law. At least 80% of the units must be occupied by at least one person 55 years of age or older. The association must show an intent to be housing for older persons. And the association must do regular reviews every other year at a minimum to show that at least 80% of their units are occupied by one person 55 years of age or older. So an association could fall out of being an age-restricted community and qualify for the exemption if more than 20% of their units were occupied by everyone under the age of 55, because the minimum requirement is that at least 80% of the units must be occupied by at least one person 55 years of age or older. If the association fails to keep track of the number in its community, it fails to do surveys or other reasonable means of determining that information every other year, then it could fall out of compliance. I believe that homeowners associations and age-restricted communities are very closely tied. There are different types of communities that are also age-restricted, such as a mobile home community or manufactured home. So there are other types that are like apartment or rental communities. So under the law, there are no exemptions for other age groups other than if a community has at least 80% of the units occupied by one person 55 or older. And the reality is that a lot of the age-restricted communities already existed at the time that the Fair Housing Act was amended to prohibit housing associations from discriminating against children under the age of 18. And so the 55 plus concept already existed in many communities, and it was really just incorporated into the law. There are no similar types of exemptions for any other age groups.